Ladies and gentlemen, welcome to the QUT Faculty of Law for today's conference on intellectual property and education in the age of COVID. As is always the case, we'd like to acknowledge the traditional owners, and in keeping with the spirit of reconciliation, we acknowledge the traditional owners of the lands where QUT now stands and recognise that these have always been places of teaching and learning, and we wish to pay respect to their elders, past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islander people continue to play within the QUT community. And in the context of debates around intellectual property and education, there has been very significant discussion about the importance of Indigenous intellectual property. Today's event is going to look at some of the relationships and connections and intersections between intellectual property and education. It will cover many different species of intellectual property, spanning copyright law, trademark law, patent law, trade secrets, and questions of licensing. In many ways, the conference today is also going to span an array of different disciplines within education, everything from the creative industries to medicine and biotechnology and even clean technology. In addition, this event is also going to focus upon open licensing within the educational institutions. So the use of open licensing to promote open access, open innovation and open data is also a very kind of important dimension in terms of the debate and discussion over intellectual property and education. This event is also going to focus upon the role of universities and educational institutions and research organisations in responding to the coronavirus COVID-19 public health crisis. So universities and research institutions have a very particular special role to play as keystones in the knowledge infrastructure. They are generating a whole wide range of technologies that could be of use in tackling the coronavirus crisis, including vaccines, treatments and diagnostics, as well as a range of other public policy solutions. So this event, amongst other things, is going to think about ways and means in which we can encourage public transfer of some of those research and public policy solutions. Finally, this event is also going to be an Australian launch for this research handbook on intellectual property and technology transfer, edited by Professor Jacob Rooksbury from Gonzaga Law School. This collection provides a comparative analysis of how an array of different countries manage intellectual property and technology transfer from educational institutions, and also kind of includes a contribution by myself looking at intellectual property and higher education and 3D printing. So welcome everyone. I hope you enjoy today's range of presentations looking at different aspects of intellectual property and education. Thank you. Our last session of the day is going to look at open access and education. To begin this discussion, Dr. Kylie Pappalardo is going to be talking about negotiating the production, management and ownership of knowledge in the 21st century university. Dr. Kylie Pappalardo has just been promoted to a senior lecturer in the Faculty of Law at QUT, and she's also a chief investigator in ARC Discovery Project, looking at intellectual property and higher education. Dr. Kylie Pappalardo.
Thank you. So COVID-19 has introduced a great deal of uncertainty into the university environment, especially around teaching, but there has been uncertainty in the research environment for a very long time, especially as regards to how research is owned, managed and disseminated. So today I would like to talk a little bit about a new ARC Discovery project that aims to investigate this issue. But first, a little bit more about what the problem actually is. So producing and disseminating knowledge is core university business, but often the systems and policies and processes in place within institutions, and also some of the external pressures that can be applied to that through the intersection of those policies with law and with industry practice, can make this very complicated. And it becomes a very difficult issue for researchers and managers to navigate, particularly when there are different pressures on researchers at different stages of their career. So this is just a little example of all the myriad of policies that can apply to research production, management and dissemination within universities. The policies that usually govern this area are the intellectual property policies, although they can be split up into smaller policies around copyright or patents, for example. But there are also often research commercialization policies, data management policies, authorship policies, open access policies, publishing policies, and all of these can exist within the same institution, and they may actually conflict in small but significant ways. So just a few more specific examples, not singling out any particular university here because the problem is very widespread, but just a small example of an IP policy at one university where, for example, they define IP very broadly to include basically anything that is created within the university, including copyright, but in the same policy, it says that copyright is dealt with in a different policy, and that is hyperlinked, and when you follow the hyperlink, that leads not to a copyright policy, but to a statement of copyright over the university website. And I was unable to find a separate copyright policy. So often policies will refer to other policies which may or may not be easily discoverable by researchers. Adding to complexity and potential confusion is that ownership rules will often have caveats or will break up ownership in many different ways. So in this same IP policy, it states that anything created by staff within their university employment is owned by the university, except for scholarly publications, which are owned by the researcher, except for anything within the scholarly publication that might be considered separate IP, which is still owned by the university. If I flick forward quickly, this is corroborated by the research data policy at the same university, which says research data is owned by the university, and also research records, which is defined to include lab notes, fieldwork notes, graphs and charts. So within a scholarly work that is ostensibly owned by the researcher, there is likely to be different things that are owned by different parties, which can be very confusing for the researcher trying to figure out how to deal with that. They may also not even be aware of those conflicts. Conflicts also arise around publication and the differing incentives within an institution around broad publication and open access and potential for research commercialization, particularly in science fields where the university might be wanting to apply for patents. So again, in this IP policy, it expressly states that publication of research is encouraged unless there might be commercial uses of that research, in which case the researcher must notify the commercialization arm 30 days before publication, and they will conduct a commercialization assessment. Whether or not researchers are actually aware of these procedures is an issue that we plan to investigate through our discovery project, which I'll talk a little bit more about in a moment. As I said, this can often conflict with open access policies at institutions. So this is at a separate university. Both the IP policy and the open access policy provide that the university owns all IP created by staff within the course of their employment, including for scholarly works, which is a little bit unusual. However, the university assigns the right to publish the scholarly work to the creator of the work, but this assignment is subject to a perpetual, irrevocable license to use the work for educational, research and commercialization purposes, and to put the work in the university institutional repository. Now, our issue with this particular policy is that it presumes a certain level of knowledge on the part of the researcher. So it assigns back to the researcher a very specific right under copyright law, which is the right to first publication. And it makes that assignment subject to conditions. It requires the researcher to understand the law and to understand agreements. So university policies are underpinned by law, particularly the Copyright Act, and the law is not always easily understood. For example, the Copyright Act is one of the longest and most complicated pieces of legislation we have in Australia, and contracts or publishing agreements that researchers enter into may be similarly complicated. So navigating this thicket is not straightforward. The onus is often placed on the researcher to do that navigation on their own. And it's not always clear where within their institution the researcher can find help. And what occurs then is that where it is all too hard or too complicated, or the researcher is not aware of the restrictions that are placed on them, it is likely that they are actually signing away rights in publishing agreements that they don't actually have, or otherwise dealing with rights that they don't actually have. These problems are exacerbated by university bureaucracy, which means that policies are produced and implemented by different people in different departments within an institution with different goals, different disciplines, and so it's not necessarily surprising that these policies may conflict in different ways because they're often advancing different agendas within the same institution. Added to this is that researchers may receive conflicting messages about what they are supposed to do with their research. And this is particularly problematic for early career researchers or higher degree research students. So there may be pressures on them from, say, their head of school or supervisor or upper management within the university to publish in quality outlets for their research, which usually means that the research is locked down fairly heavily, but also to achieve research impact with their research, which requires that the research be disseminated quite openly and quite broadly. So there can be a real tension between the goals of open and broad dissemination and the goals of achieving quality, which usually means that publishers are exercising a great more control over that research. So what happens here is that there are potential legal issues about ownership. Researchers are frustrated and confused. There is an ongoing process of institutional policy review that tends to go around and around, and which is very time intensive, and that research may not be disseminated as broadly as it could be because of all these conflicting policies and confusion. So just to read a quote from our project description, poor management of knowledge ownership and dissemination can thwart research objectives. Outcomes may not be usable. Projects may be delayed or stopped, articles may not be published, or may be unnecessarily restricted to limited audiences. These problems can put a brake on scholarly advancement engagement with non-scholarly audiences, and the real-world impact of Australian university research. So this is where our discovery project comes in. It seeks to look at the fundamental tension that is at the heart of research production and dissemination between a copyright system that is predicated on limiting end-user access and a research impact agenda that depends on broad dissemination and broad social engagement with research outcomes. So we will investigate this tension, and we seek to bring increased coherence to this policy framework within Australian universities around research. Our project team is a very strong one, I think. It includes Professor Kathy Bowry at the University of New South Wales, Professor Kimberly Weatherall at the University of Sydney, Professor Irene Watson at the University of South Australia. Professor Watson is also the Pro-Vice Chancellor of Aboriginal Leadership and Strategy at UniSA, and that is relevant for our project, as I'll explain in a minute. There is myself and Emeritus Professor Tom Cochrane here at the Queensland University of Technology, and there is Emeritus Professor Jill McHugh at the University of Technology, Sydney. Our project has really 5 aims. We plan to map the policy framework and analyse the policy framework that I've just described that relates to ownership and dissemination of research and how these policies interact within and across Australian universities. So this will be a comparative review, and from that we will produce a report to identify common themes and practices and to really explore those tensions and inconsistencies that result within those policies. We will also investigate how academics and managers are currently making decisions about prioritising these competing imperatives around research. And we will do this investigation through in-depth, semi-structured interviews with researchers at all stages of their careers in both STEM and HASS disciplines, with executive and faculty research managers, and with those people at the universities who are responsible for developing policies and implementing policies, including university librarians. Part of our project also looks at the way this policy landscape impacts on Indigenous researchers. So we plan to consult, and these consultations will be led by Professor Watson, with Aboriginal participants in university research to better determine how ownership of Aboriginal and Torres Strait Islander knowledge can be appropriately valued and acknowledged within the university sector. And from these first 3 stages of the research, we will then develop recommendations and proposals to make this policy framework more coherent across universities. These recommendations will be developed in consultation with key stakeholders and with international experts in this area. And finally, we plan to produce best practice guides to educate and empower research managers around the tools to make decisions for access, use, management and dissemination of their research, including to better understand the laws that govern these environments and underpin those policies within their institutions. So we are right at the beginning of our project, but the anticipated benefits that we hope will accrue from this project is that it will facilitate the conditions for innovation through improved end-user access to research. It will help improve institutional efficiency at Australian universities. It will help those universities meet the expectations of public and private funders of research in a cost-effective manner, and it will maximise the benefits from existing Australian copyright law provisions insofar as they relate to research and knowledge produced within the university sector. Thank you.